Hi all, welcome to Sini's classroom, myself Sini Madhavan. As you know, we are discussing about the second stage in the formation of a company, that is incorporation or registration. In the previous class, we discussed about what is incorporation and what are the procedures involved in the incorporation process or registration process, in which we discussed only two procedures, that is availability of name with the registrar as well as drafting and printing of memorandum and articles of association. There are two more procedures that we need to discuss, that is the documents to be submitted before the registrar as per section 7 subsection 1 to get your company registered, as well as issue of certificate of incorporation by the registrar. And in this session, we will be discussing about the leftover two procedures that I have mentioned it now. That is to the documents that we need to submit before the registrar as well as issue of certificate of registration. Since it is a lengthy process, I have divided it into two sessions. In this second session, we are going to learn about the other two procedures that we didn't discuss earlier. So let's get started with that. The third procedure in the incorporation or registration of a company is to submit certain document for registration, and that is again mentioned in section 7 subsection 1 of the Companies Act 2013. The first document that we need to submit is an application form. If you are forming an one-person company or if you are trying to incorporate in a one-person company, then the form that you need to use is INC 2. And in the case of other types of company, the form used will be INC 7. So, depending upon the type of company, you have to submit an application in the prescribed form towards the ROC. Okay, that is the first document that you need to submit, that is application for incorporation. That is, for getting the company registered, the promoter need to submit an application. Again, depending upon the kind of company, whether an OPC or any other kinds of company, the specified form should be utilized. INC 2 for incorporating a one-person company, INC 7 for incorporating other kinds of company. Now, you are going to submit an application, and along with that application, you have to submit certain documents. Now, we will discuss each document one by one. Already, you know, you have prepared drafted and printed articles and memorandum of association. The same document should be attached here along with the application. Clear? So, along with the application for incorporation, you need to submit the memorandum as well as articles of association. Before attaching that memorandum or articles along with the application, few things need to be taken into consideration. That is, the memorandum and articles of association should be stamped, signed as well as dated. Three aspects. Okay, the memorandum, you have to take the physical copy or print of the memorandum as well as articles of association. You have to stamp it, you have to get it signed, you have to get it dated. Three aspects you have to take into consideration. That is, the memorandum and articles should be printed and stamped by the appropriate state authority as per the Indian Stamps Act. Now, what do you mean by stamping or getting your memorandum stamped? What does that mean? It is nothing but getting a legal recognition. Stamp duty means a government levied tax on transactions. So, the memorandum that you have drafted and printed should be stamped as per the Indian Stamp Duty Act. Okay, again, when you are trying to stamp, when you are trying to get it stamped by the authority, it depends upon the stamp duty, depends upon the state in which you are getting your company incorporated or the jurisdiction within which the company is being incorporated. If you are trying to incorporate the company or if you are going to start or commence the business in Kerala, then you have to follow the Stamp Duty Act of Kerala government. That is what it is mentioned. The stamp duty payable on the memorandum and articles of association shall be determined on the basis of the place of incorporation of the company. Again, the stamp duty varies according to different states in our country, depending upon the Stamp Duty Act. of that particular state. So along with the application, the first document that you need to attach is the memorandum as well as articles of association. Again, both the documents should be stamped, signed as well as dated. The stamping matter I have just discussed with you, that is the memorandum and articles should be printed and stamped by the appropriate authority as per the Indian Stamps Act. So you have to get your memorandum and articles stamped by the authority. Fine. The next one is to get the memorandum as well as articles signed by the subscribers. Okay, subscriber means whom? The person who are willing to form themselves into a company. The persons who have come together to form a company, they are known as the subscribers. So the next aspect is to get that stamped memorandum signed by the subscribers. That is what we call it as a subscribers towards the memorandum. Okay, so for the first step was to stamp the memorandum. Already you have drafted and printed the memorandum. Now you need to get it stamped as per the Stamp Duty Act prevailing in the state in which you are trying to incorporate your company. Okay. Now the second one is to getting it signed by the subscribers towards the memorandum. So the memorandum and articles should be signed by the subscriber. Subscriber means a person who are willing to form themselves as a company. Now, when we say about the subscribers towards a memorandum, as you know, if it's a public company, the minimum number of persons required to form a company is, a public company is 7, and as far as a private company is concerned, it is 2. The maximum in the case of public company, there is no restriction, and as far as the private company is concerned, it is 200. So, depending upon the number of subscribers based on different types of company, they need to sign in the memorandum. Okay, if it is a public company and you are forming it with 10 people, then the 10 people will be the subscribers to the memorandum. If you are forming a private company and 3 people together come to form a company, then that 3 people are the subscribers towards the memorandum. Okay, so each subscriber towards a memorandum or subscribers should sign the memorandum. Okay, they have to sign the memorandum. Each subscriber need to sign the memorandum. They have to specify their name. They have to specify their father's name, their occupation, address, nationality, and so on. Necessary documents that is specified in the Companies Act. So the persons who are willing to form themselves into a company need to get the memorandum as well as articles signed. That is, the subscribers need to sign the memorandum and articles of association. They have to put their signature, they have to write their name, their father's name, their occupation, their nationality, the number of shares that they have subscribed, and any such other information that the ROC requests to frame. Similarly, the sign of the subscribers should be again countersigned by a witness. The witness name, their details like father's name, their occupation, nationality, address, and any other such information that is demanded by the ROC should be again framed there. Okay, so after stamping, the next aspect you need to take into consideration is getting the memorandum and articles signed by the subscribers. Depending upon the types of company, the subscribers differs. Next, if the subscriber is an illiterate person, there might be such situations also. In such a case, they can provide, instead of signature, they will be providing their thumb impression. Okay, if the subscribers, any of the subscribers towards the memorandum is an illiterate person, then that person can put thumb impression instead of signature. The next one is, when the subscribers towards the memorandum is a body corporate, that is, the subscribers needn't be always an individual. They can also be a body corporate, that is, they can be another company. In such case, the signature put by the subscriber will be that of someone representing the company, and that can be a director, an office employee that is being again authorized by the company to sign on behalf of that particular company. Is that clear? So a subscriber needn't be always an individual. A subscriber towards a memorandum can be another company. In such case, the company will be authorizing an official to sign on behalf of the company. And that official might be a director, an office employee, or any other official which is being authorized by the board of directors to sign on behalf of the company. So a subscriber needn't be always an individual. It can be a company also. So when there is a matter of signature to be put in the memorandum, it can be signed by an authorized person by the other body corporate. So they will be passing a resolution to make a director by giving a director of that company to sign on behalf of the company in the memorandum of association. Again, that is an authorization. So here, the second aspect is about signing the memorandum. So every subscribers should sign the memorandum as well as articles of association. They have to mention their name, they have to mention their occupation, their nationality, their address, their father's name, the number of shares that they are taking from the company and subscribing from the company. Everything should be mentioned. The ROC will be intimating them what and all information need to be framed. Again, that signature of the subscriber should be witnessed by another person. Again, that witness details should be provided. If the subscriber is an illiterate person, then the thumb impression is more than enough. And again, when the subscriber is a body corporate, then some person authorized to represent the company should come and sign the memorandum and articles of association. Is that clear? So we have stamped it, signed it, and now the third one is to get it dated. That is dating of memorandum and articles of association. When you say dating, you might feel very weird. It is nothing but the date mentioned in the memorandum and articles of association, and the date so mentioned is nothing but the date in which the memorandum or article is being stamped. It can be a date, it should be a date in the date in which it is being stamped, otherwise a date after that, but not a date prior to stamping. If you have stamped it today, then you can put that date on the memorandum, or any upcoming dates also can be framed in the memorandum, but you cannot put a date prior to stamping. That is what is mentioned here. The date should be on the date of stamping or date later than the date of stamping, and not a date prior to the date of their stamping. So you cannot put a date in the memorandum, a date before the stamping. It should be a date, either the date at which it has been stamped or a date later to stamping. Okay, so these three aspects should be given emphasis. So when you are giving the memorandum or articles along with the application, you have to take into account whether it is stamped. Only after stamping, the subscribers will sign, and also you have to mention the date in which the memorandum is being created or it is being stamped. The three aspects should be taken into consideration. Okay. Another document that need to be submitted along with the application is a declaration from the professional stating that all the requirements of the Companies Act has been complied by the proposed company. That is, the proposed company or the promoters have complied with all the legal requirements that is necessary for the formation of a company. So such a declaration should be obtained from a professional. Now, who is a professional who can give such a declaration? Let's examine. It should be given away by an advocate. So an advocate is a professional who can give such a declaration. Second one is a chartered accountant, a cost accountant, or a company secretary in practice who were involved in the formation of the company or who were engaged in the formation of the company, and a person whose name is being provided in the articles as a director, manager, or secretary of the company. So any of these professionals can give a declaration that the company is following all the requirements that is necessary as per the Companies Act to form a company. That is, they are complying with all the rules and regulations or the law that is being mentioned in the Companies Act. Such a declaration given away by the professional should be attached along with the application. So we have filled an application. Along with that, we have attached the memorandum and articles of association, which is again printed, stamped, signed and dated. And the third one is providing a declaration given away by the professional regarding or stating that all the requirements of the Companies Act has been followed by the proposed company. Okay, is that clear? Another document that need to be submitted along with the application is an affidavit of subscribers and first directors of the company. The literal meaning of affidavit is written statement confirmed by an oath, or we can call it as an affirmation. Okay, so an affirmation given away by the subscriber as well as the first directors should be attached along with the application. So in this written statement, the subscribers as well as the first directors will be stating that they are not convicted of any offense, or they are not found guilty for any breach of duty or conducting any fraudulent activity or misfeasance. Also, they will be stating that whatever information that they have framed along with the application is complete, correct and done with a due diligence. So these are the matters that should be written in that particular statement. So along with an application, we need to attach an affidavit given away by the subscribers as well as the first directors of the company. And the affidavit or that affirmation or that written statement states that they are not convicted of any sort of offense in connection with the promotion, formation as well as management of the company. And they have not been found guilty for any breach of duty or any fraud or any misfeasance under this act or any other previous Companies Act during the last 5 years. So during the last 5 years, they are not held guilty for doing any sort of breach of duty or fraudulent activities. As well as the written document should state that the affirmation should state that all document filed with the registrar is correct and complete and done with due diligence. Okay, so such an affirmation or such a written document should be obtained from the subscribers to the memorandum as well as the first directors mentioned in the Articles of Association. So the affirmation is about that they have not done anything, any fraudulent activity, breach of duty or misfeasance, as well as they are not convicted of any offense in connection with the promotion, formation as well as management of the company, the proposed company. Similarly, all the documents filed with the registrar is correct and complete and done with due diligence. Another document that need to be attached along with the application form is a power of attorney. You might have heard about the concept power of attorney. Power of attorney is nothing but an authority to act on behalf of another person. So here, a company, the proposed company need to give a copy of power of attorney, a general power of attorney on a judicial stamp paper that is of the appropriate value that is applicable in the state in which the company is being incorporated in favor of one of them or any other persons for making any sort of alterations in the memorandum, articles or any other document. That is, here the power of attorney means an authority to act on behalf of another person. So one particular person is given the power to act for the other entire persons. So from among the subscribers, one person will be given the power to make necessary alteration that need to be conducted in the memorandum or articles of association. Alteration here means the change in the memorandum or articles of association. So any such incident happens, there is a situation wherein we need to change the articles, we need to change the memorandum or any other documents. Through a power of attorney, the authority will be granted to one of the subscriber. If any such power of attorney is given, that should be attached along with the application form. Are you getting me? That is, power of attorney means what? An authority given to act on behalf of another person. So here, as far as the proposed company is concerned, they need to issue a power of attorney in a judicial stamp paper, again valued as per the state act where the company is going to be incorporated. Depending upon the value of the judicial stamp paper depends upon the state in which the company is going to be incorporated. In such a judicial stamp paper, a general power of attorney should be given to any one of the subscribers to act on behalf of others in the matters of, in many matters, again the matters of making alteration in any of the documents, memorandum or articles or any other documents on behalf of the other subscribers. So that copy of power of attorney should be attached along with the application. The next one is, the next document that need to be attached is particulars of the first directors along with the consent of the directors to act as the director of the company. That is particulars of the first director. You know who is a director? Director is regarded as a brain of the company. He is regarded as, he or she is regarded as the brain of the company. That is, the management of a company is always vested in the hands of board of directors. The entire shareholders of the company cannot come and manage the company. In such situation, from among the shareholders, few people will be, on a democratic principle, will be elected as the directors. Collectively, they are known as board of directors and individually they are known as the directors. They are the brain of the company in the sense that they are the people who will be managing the entire company. Okay, so when a person is being elected as a director, the particulars of those directors should be framed along with the application, as well as the consent of the director to act for the company as in the position of a director should also be obtained. We cannot compel a person to be a director of a company. Okay, if the person is willing to act as a director, the consent of that person to act as director should also be taken, and that consent should also be attached with the application. So two aspects, one is the particulars, the details of the directors, as well as the consent obtained from the director to act as the company's director. So that should also be attached with the application. Now, what are the particulars of the director? It is again given the name of the person, their surname, family name, the director's identification number. A person when becomes a director will be provided director's identification number as per the Companies Act 2013. So such a number, his residential address, nationality and such other particulars that is being asked to be produced by the ROC should be submitted in the particulars. Also, the proof of identity should be filed with the application. So here in this document, the particulars of the directors should be included. All the details of the directors, as well as the consent of the director. You have to get a written statement from the director stating that he is willing to act as a director of the company. So such a consent letter should also be obtained from the director and that should be attached with the application form. So the consent to act as a directors and particulars of interest of the first director in other firms or body corporate. Look here, one director, otherwise a director can act as a director of another company also. Not necessary that he can be a director, he or she can be director in your own company. That person can act as director in some other company also. Similarly, these directors might be having some sort of interest in other company. They might have purchased shares in some other company. So any such interest if a director is having, they have to disclose it. That is, the director that you are appointing towards your company, the director that you have appointed towards your company should reveal his interest in some other companies also. If he or she is having such a interest. That interest might be in the form of what? That person will be a director in some other company. Otherwise, that person will be holding shares in some other company. Any such interest, that director need to reveal that before this proposed company. Such details should also be furnished with the application. So what are all details? Particulars of the director, that is the details of the directors. The consent of the director to act as one of the board of directors of the company. And the third one is, if that person is having an interest upon some other company, the same should be furnished with the proposed company. Such information should be attached along with the application form. Is that clear? Another document that need to be submitted along with the application is particulars of subscribers. As you know, subscribers are those persons who come together jointly to form a company, isn't it? So the subscribers towards the memorandum need to provide their details, that is, their name, their surname, their family name, their residential address, nationality, and any such other particulars that is demanded by the ROC along with the identity proof. So, along with the application for registration, you have to attach the details of the subscribers towards the memorandum as well as articles of association. As you know, in the case of a public company, the minimum subscriber is 7, and in the case of private company, the minimum subscriber is 2. And the maximum subscriber in the case of public company is no restriction, as well as private company is 200. So depending upon the type of company and depending upon the number of subscribers, the details of the subscribers should be provided along with the application. The details should consist of their name, their surname, their family name, their residential address, nationality, and all other particulars that is again demanded by the or required by the Companies Act or the ROC. Okay, again that particulars should also include the ID proof which should be attached with the application. So that is one of the documents that need to be documented along with the application. The last document that we need to submit along with the application is furnishing verification of registered office. As you know, even if it is a proposed company, the company didn't come into existence, they should have a premises, they should be having a building, or they should be having a location, a situation wherein the company is being located. Okay, such a locality or such a location or a situation should be examined by the registrar. So there are two cases. One is if the location of the registered office of the proposed company is finalized even before incorporation, then you have to submit an application form, that is INC 22, towards the registrar to get your company, proposed company's location verified, or the building verified, or the situation verified. Okay, so that is prior to incorporation. Before incorporation, if you are finalized the registered office, then that office should be verified by the registrar. For the same, you have to give an application, and the application form is INC 22. Is that clear? Now, even if after, or if the location is not fixed at the time of incorporation of the company, that is, you are not having a registered office as of now at the time of incorporation of the company, there is no problem. The only thing is, from the 15th day of incorporation, that is, after getting the incorporation certificate, within 15 days of getting the incorporation certificate, you should have a registered office, wherein acknowledgements can be sent, wherein communications can be sent. That is, within 15 days, you have to ensure a registered office, and that should be again verified by the ROC. And such an information should be furnished towards the ROC within 30 days of incorporation. Are you getting me, or you are getting confused? There is nothing. Just understand, you have to get your registered office verified by the ROC. That is, before incorporation, if you are having a registered office, then it is well and good. Only thing is, you have to inform the same towards the ROC in an application form. The name of the application form is INC 22, or the number of the application form is INC 22. In INC 22, we have to file application towards the ROC to get our registered office verified. In case you are not having a registered office at the time of incorporation, no problem. The only thing is, when you get the incorporation certificate, from that day to 15th day, you have to find a registered office. You should have a registered office, or you should establish a registered office which is capable of receiving and acknowledging communication. That is, you should get an address. Only name is not necessary. Name alone cannot, as I said earlier, name is not the only factor with which you can ensure your identity. There should be an address also, isn't it? That is also another factor. So there should be a registered office within 15th day of receiving that incorporation certificate. That is, if you get incorporation certificate today, within 15 days you should establish a registered office so that you get communication to that particular address. And the same should be informed to the registrar for verification within 30 days of receiving the incorporation certificate. That is, the company shall furnish the information for verification by the registrar within 30 days of the incorporation. So the document that you need to furnish here is about the registered office, verification of the registered office. If you are having a registered office even before incorporation, then you need to file the same in a form INC 22 towards the ROC. If you are not having such a registered office, then from the date of incorporation till 15th day of after that incorporation, you have to have a registered office. You should have established a registered office, and that should be again informed to the ROC within 30 days of incorporation. So these are the documents that you need to file along with the application to get the company registered. Just note it down one by one. As I said earlier, take a logical break in between, identify what are the documents, then club it together. So this is just the third procedure in the registration of a company. That is quite lengthy. You have to take into consideration lots of documents that you need to submit along with the application. So can you just recall what are the contents that we need to frame along with the application? What are the documents that is being mentioned in section 7 subsection 1? First of all, application. Okay. Secondly, you have to get your memorandum and articles printed, stamped, signed and dated. That should be attached with the application. Then after that, a declaration from the professional stating that all the rules and regulations of the Companies Act has been complied with. Then an affidavit, an affirmation given by the subscribers as well as the first directors that they are not convicted of any offense or any fraudulent activity, and whatever information that they have framed is correct and with due diligence. The next one is subscribers details, the particulars of the subscribers, all the details of the subscribers. Then the copy of power of attorney. Then the particulars of the first directors, their consent as well as their interest on other companies. Then furnishing the verification of registered office. The details, furnishing the documents relating to relating to the registered office. So these are the documents that you need to submit along with the application for getting your company or getting the proposed company registered. Is that clear? Now we are going to discuss the last procedure in the formation of a company, that is issue of certificate of incorporation. In the previous procedure, we learned different documents that need to be submitted before the ROC to get it registered. That is an application form along with several other documents. So the registrar, on the receipt of that application and the documents attached along with the application, will be making a scrutiny of the same, and if he or she is satisfied, that is, the registrar is satisfied with the application and the documents furnished, they will be issuing a certificate of incorporation. Certificate of incorporation means that the company came into formation. Okay, that is known as certificate of incorporation. So the registrar, on the receipt of the application and the necessary documents attached with that, will be verifying it, scrutinizing it, checking it, and then giving away the consent that the company is formed or the company is incorporated. And they will be issuing a certificate, and in that certificate, it will be stated that the company is formed or incorporated, and the date mentioned in that certificate denotes the date in which the company came into existence or the company came or formed into existence. Okay, so on being satisfied with the document, the registrar will register the company as well as all the documents and place the name of the company in a book known as Register of Companies. Only if he is satisfied with the documents given or the application given. So, scrutinizing the application, the documents, he or she will be giving away the consent that the company is formed. Again, in a book known as the Register of Companies, the registrar will be entering the name of the company. And after the registration, the registrar will be issuing the certificate of incorporation, a certificate which denotes that the company came into force, that is the formation of the company in a prescribed format. Again, the certificate of incorporation will contain a corporate identity number, which is a distinct and unique number given away to a company. Each company will be having distinct and unique corporate identity number, again given by the ROC, when they are satisfied with the application as well as the document that is being furnished. Again, the certificate of information will be having a date, and that date denotes that it is the date of incorporation of the company. On that day, the company came into force. And the company should maintain at its registered office, preserve at its registered office all the documents that is being furnished towards the ROC, like memorandum, articles and all other documents, along with the copies of all the documents along with the certificate of incorporation should be maintained by the company at its registered office. That is the last procedure in the formation or incorporation of a company. Hence, after completing the third procedure, if the registrar is satisfied with all the documents and the application furnished, they will be issuing a certificate of incorporation and the company comes into force. Is that clear? Am I making a sense? So there are 4 procedures in the incorporation of a company. The first one was application for ensuring the availability of the name. Second one was drafting and printing memorandum and articles of association. And third one was the documents to be submitted for getting the company registered as per section 7 subsection 1 of the Companies Act. And the fourth one is issue of certificate of incorporation. These are the 4 procedures that need to be undertaken for getting your proposed company registered or incorporated. I just want to revise you those concepts that we had discussed in this class and the previous class. As I said in the previous class, the formation and incorporation of a company involves 4 distinct stages. One is promotion, second one is incorporation, third one is capital subscription, and the fourth one is commencement of business. So we have dealt with the first stage, that is promotion. The second stage is incorporation, that is the present session, and in incorporation we have to follow certain procedures, and there are 4 procedures. Application for ensuring the availability of name. Second one is drafting and printing memorandum and articles of association. Third one is attaching certain documents for getting the company registered, and the fourth one is issuance of certificate of incorporation. With that, we have completed the second phase in the formation and incorporation of a company, that is registration.